Sue Moroney.
Well, thank you, Mr Chair. Pleased to have an opportunity to rise and speak to Part 5 of the Health and Safety Reform Bill. And the part that I really want to focus on for my contribution, sir, is Clause 212, which is about workplace injury prevention. And look, I know that the Honourable Ruth Dyson has got an equally important and different contribution to make around that same point. I'm going to stick to the issue that we debated at Select Committee around this part, because, Mr Chair, we were given some assurances by officials that I want to make sure, and I guess I want to ask the Minister and the Chair to make sure that it is also her understanding of the assurances that we were given, because this was exploring the issue around workplace injury prevention programs, which are able to be provided, or have to be provided actually, by both WorkSafe and by ACC. And currently what we have, my understanding is that in the ACC Act, which Clause 212 refers to, we have a provision in there that requires the expenditure of the money that's put aside for workplace injury prevention programs, that it be used in a way where they've got to demonstrate that those workplace injury prevention programs would result in a reduction in levy rates or expenditure. In fact, the wording in the Act is that a reduction in levy rates or expenditure is expected. And what I raised at Select Committee was the concern that, in fact, if some really good workplace injury prevention programs would, by the nature of being successful, sometimes increase levy rates, because, sorry, Mr Chair, I'm just going to have to go backpedal a little bit and explain to people about how ACC levy rates are set. They are set in a manner where if an industry or a sector has a large number of injuries or accidents or workplace deaths, then they will have a higher ACC levy, and if they have a lower rate of notifications of injuries or deaths or accidents, then they have a lower levy. So it would seem intuitive that workplace injury prevention programs would bring the accident rate down, the death rate down, and therefore lower the levies. However, in some instances, and particularly with regard to occupational disease, that can actually be the opposite effect. So what I mean by that, Mr Chair, is that sometimes people don't know that the symptoms that they are suffering from are as a result of an occupational disease that they may have picked up some time earlier, some long period ago at a different workplace, because they simply are unaware that those symptoms are associated with perhaps a chemical that they used to handle in a previous workplace. So a workplace injury prevention program that actually raises awareness of occupational disease, the symptoms associated with it, and the outcomes of that may actually increase the number of claims that are put forward to deal with the outcome of that occupational disease, and therefore could actually end up in an increase in the ACC levy being paid by a particular industry or sector. So as perverse a result as that may seem, I was concerned that Clause 212 in Part 5 of this Act may in fact stop such workplace injury prevention programs from being accepted and approved and paid for by either ACC or WorkSafe because of what that section says. Because it does say that Section 264A of the Accident Compensation Act 2001 requires WorkSafe and ACC to at all times have a workplace injury prevention plan that meets the requirements of that section. That section, as I said before, requires that a reduction in levy rates or expenditure is expected as a result of those. Now, Mr Chair, why I raise it is that we were given assurances by officials, and I would like those assurances repeated by the Minister for the benefit of the House, that while that may well be an expectation that is put on programs that are funded by ACC, that particular provision would not be actually extended to the Mr. Chair? The workplace injury prevention programs provided by WorkSafe. Now, I'm in the committee stages debating this bill, rereading clause 212 and feeling nervous all over again because it does stipulate both ACC and WorkSafe have to have regard to that clause in the ACC legislation. I'm now just as nervous as I once was that we are going to have this provision applied to WorkSafe programs as well. So, Mr. Chair, I did though ensure that the Select Committee, because I think the Select Committee agreed with the issues that I was raising, we wanted to ensure through our commentary that we were clear in our instruction to Parliament about what our understanding was. So, in the commentary that's been reported back from the Select Committee consideration of this bill, there's a section on page 16 of that commentary, and I just want to read it out because I want to make sure that the House understands what the Select Committee believed from the official advice, and I would like the Minister to reiterate that we have got this right. So, under the heading Injury Prevention on page 16 of the commentary from the Select Committee, it says, although reduction in ACC levies is not the only driver of injury prevention programs, we were concerned that such programs would be constrained to only achieving reductions to levies, when some programs should raise awareness and therefore increase the number of ACC claims being made. We were assured, and that means by officials, we were assured that WorkSafe's injury prevention programs can continue to be funded by WorkSafe and that such funding would not be dependent on a need to achieve a reduction to ACC levies as a criteria. Mr. Chair, getting an assurance on that before we vote on this part of the bill is very important because we want to make sure that the Minister's understanding is the same as what the Select Committee was advised. Otherwise, the Labour Party would continue to have a concern that a whole range of very effective workplace injury prevention programs would not be able to be funded either for ACC provision or by WorkSafe provision, and that would particularly put at risk injury prevention around occupational disease, but it wouldn't just be occupational disease. It would be anything where raising awareness of the issue would in fact perhaps lead to more claims being put forward to ACC and an increase in levies occurring or expenditure occurring by ACC. Mr. Chair, further on the issue of workplace injury prevention, I do want to note that under this government, the funding for workplace injury prevention programs fell drastically, that it has somewhat been restored, but still not restored to the levels that it was way back in 2008. And I think that in conjunction with clause 212 in Part 5 of the Act, the government needs to give us an assurance that the funding levels will not only return to what they were way back in 2008, but in fact catch up with inflationary costs that have occurred since then, catch up with the increase in workforce participation that has occurred since then, and make sure that we have workplace injury prevention programs that are actually funded to a level that they make a difference, because this is what this bill is about. It is about actually preventing injuries at work where we can do that best. The reason why this bill has come about is because we've got such a lousy record when it comes to preventing injuries in the workplace, and certainly the government's cuts to funding since 2008 have not helped in that regard at all. Mr. Chair, the other contribution I'd like to make on Part 5 is with regard to the health and safety at work strategies. Because again, in clause 211 in Part 5, we know that the Minister must publish a strategy called the Health and Safety at Work Strategy that sets out the government's overall direction in improving the health and safety of workers. I think when that is published, it's going to be very interesting to see what the Minister has to say about the level of risk on farms, because certainly there's a lot of confusion over what the strategic view within the National Party is on that issue. So I look forward to seeing what they have to say about the unforgivably high number of workplace deaths that we have from the farming industry, and hope that it certainly isn't explained in that strategy as being low risk, because I think every New Zealander understands that that's just simply not the case. So the strategy must be developed jointly with WorkSafe, and the Minister must take reasonable efforts to publish the first strategy within 24 months after the commencement of the section.